Hello everyone, welcome to Sunya IAS and welcome to this lecture. Today we are going to resume our fundamental rights and the topic through questions. So let's start. I hope you have attempted all the questions and then you are starting this particular video watching. Chalo, let's start. So we have done 4 questions, coming on to the fifth one. Concerning the right to equality in fundamental rights, consider the following statements. The right to equality prohibits discrimination on grounds of religion, race, caste, sex, or place of birth. The right to equality allows the reservation of seats in educational institutions. And the right to equality ensures uniform civil laws for all religions. Now, how many of the above statements are correct? UPSC's pattern now is such that you cannot really eliminate any statement anymore. Although you have to apply your logic to make certain statements incorrect. So over here, first statement is absolutely correct. Article 15 says that. We've already studied it in the last lecture. Then reservation of seats in educational institutions also is given by Article 15. Then right to equality ensures uniform civil laws. Now this is not a part of right to equality. This is definitely a part of Indian Constitution, a part of Article 44, that is Uniform Civil Code, but not a part of right to equality. So here only 2 statements become correct. Okay, nothing to explain further over here. Let's move on. With reference to right to constitutional remedies, consider the following statements. Now, writs issued under Article 32 can only be used for enforcing fundamental rights. That is one statement. A writ of mandamus can be issued against private individuals, and the power to issue writs is vested exclusively with the high courts. You have to choose the correct statements. Only one, only two, only three, or none. Now, if we go statement by statement, writs issued under Article 32 can only be used for enforcing fundamental rights. While this only mostly makes the statements incorrect, in this particular case, this statement becomes correct because of the word only. Because 32 is restricted to only the fundamental rights which Supreme Court is concerned with. If we want to fulfill other rights, we can go for the Article 226, that is the writ jurisdiction of the High Court, right? That is why we say what? What do we say? That the writ jurisdiction of High Court is wider than that of Supreme Court. The second statement, writ of mandamus can be issued against private individuals. No. Mandamus means we command, and as we discussed, you cannot issue this writ as the Supreme Court of India against a CEO of a particular company, private company, saying that please do your job. No, we cannot do that, right? Then the power to issue writs is vested exclusively with the high courts. No, Article 32 is such that it is giving the power to Supreme Courts also. So, High Courts under 226, Supreme Court under 32. So, here only one statement is correct. Fine, moving on. If you want to just know the description, and if you want to know the analysis of this Article 32, we have done it in previous class. So please watch the previous lecture. We have discussed the rates, we have discussed everything. Okay. Then a person has been arrested for an alleged crime and their family is concerned about their well-being. Which writ can the family file to ensure that the person is not subjected to any form of torture or inhuman treatment while in custody? Now, this can be a confusing statement. It is an analytical statement. Please make sure that whenever personal safety and liberty is concerned, you issue the writ of habeas corpus, that is, bring the body off. Okay, when you get this writ issued by the Supreme Court and the person, whoever has, kidnapped or took the person who you are looking for, the person has to bring that victim to the Supreme Court. Otherwise, the people can be jailed. The people will be jailed. So you want to ensure the well-being. Mandamus cannot be issued because if you remember, mandamus is issued by Supreme Court for the performance of duties. So we command. Certiorari cannot be there because it certifies the job that is done. Quo warranto, who warrants you? You might have been confused between habeas corpus and cure warranto, but please understand that make this a ground rule that whenever individual liberty is being talked about, the writ that has to be used is habeas corpus. So I hope that is clear. Moving on. The government has imposed a ban on the publication of a certain newspaper for alleged national security reasons. Now, the newspaper publisher seeks a legal remedy to challenge this ban. Which writ can be used for this purpose? Now, here you might not be knowing the exact answer, but you can go on eliminating things, right? So, first of all, you will eliminate habeas corpus, okay, because it is related with individual liberty and it is about bringing the body off. Here, the concern is about freedom of speech and expression. Now, how can you further eliminate? If you can see, the step has been taken by government and government is an administrative body. Now you have to take this action against administrative bodies. So certiorari is not applied against administrative bodies. Prohibition is not applied against administrative bodies, right? So you will cancel out certiorari and prohibition and you will go for mandamus. We command, right? So we command that you do your job of ensuring that there is freedom of speech and expression in the country and newspapers are not banned unnecessarily. We command this. Okay, so I hope you understand how you can arrive at the correct answer and this is the skill that you will develop eventually. The purpose of these sessions is that first you attempt all these questions and after you have done with you're done with these questions, that is the time that you come to these lectures and see how they could have been attempted. Fine, that is there. Every question will not be attempted by your knowledge only. Okay, please understand this. Moving on. Consider the following statements regarding cultural and educational rights. Statement 1. Minority communities have the right to establish and administer educational institutions of their choice. Statement 2 is these rights can be restricted by the state for ensuring the quality of education. Now, these kind of questions are increasingly being asked wherein your options are something like this, that both 1 and 2 are correct and 1 is the statement. So, please read the options. I will not read up all the options. They are in front of you. Now, even without knowing the exact article, you must be able to answer this question. Even if you have not remembered, even if you have not revised this particular article, you must be able to answer this question because see how generic this statement is. That minority communities have the right to establish and administer educational institutions of their choice. Why not? Why will they not have that particular right? So yes, this is correct. Right. This is correct actually. Without you knowing about right to freedom of speech and expression and without you knowing about right to religious freedom and your cultural and educational rights. So it is actually applicable under 3 rights. One is your Article 30. Article 30 specifically uses these words. Fine. That minority communities have the right to establish and administer educational institutions of their choice. But if this cultural and educational institution part was not written, rights was not written, then even if you think about it, Article 26 also gives us the same rights. Because what it is doing, it is actually giving religious denominations the right to open and administrate their institutions. Then further, if you think about it, if this was not given, even Article 19 gives us the power to open up our associations, to create associations. So it's all about how wide you can think. So definitely first statement is correct. Now when first statement is correct, then your one option is eliminated. That is option number 4 is eliminated. Now let's come to the second statement. These rights can be restricted by the state for ensuring the quality of education. Yes, they can be restricted, and of course it is also a generic statement. So yes, this is also correct. However, is the second statement explaining the first statement? No. Okay, so battle is not won if you know that both the statements are correct. You have to establish that analogy also, that whether the second statement is explaining the first statement. So it is not explaining the first statement. So answer will be option number 2. Now let's quickly know the cultural and educational rights. These are the most confusing rights which people are not very careful with. So cultural and educational rights. See, when we talk about cultural and educational rights, it has only 2 articles in the rights. So there is Article 29 and Article 30. Now, although Article 29 has the verbiage that it is about the protection of interest of minorities, but when you actually study the article, you come to know that it is applicable to any section of society. Any section of society. However, Article 30 is applicable only to linguistic and religious minorities. So, although the Constitution has not defined the word minorities for sure, but here it has written the word minorities in Article 30, linguistic and religious minorities. So language wise and religion wise, Article 30 is just for the minorities. Now, what is Article 29 giving to the any section of society? So it can be Hindus, it can be Sikh, it can be Muslims, it can be anyone who wants to conserve, and protect. It is for conservation and protection of what? Of their culture. Culture includes their language. So if they want to run a particular course in their language, they can. They can promote their script. They can promote their culture. They can promote and preserve and protect their culture. So it's the right to conserve, right? Then further, it is also written that in the institutions maintained by the state, in the educational institutions maintained by the state, no person shall be denied the right to be admitted on the basis of religion, race, caste, or sex. No, not sex, language. Because here, sex is a part of discriminatory measures because there are all boys school, there are all girls schools, they are there, right? So, discrimination on the basis of sex can be there. But here, religion, race, caste, and language cannot be barriers for the denial of admission to state-run educational institutions. Okay, so religious and linguistic minorities, religious and linguistic sections are covered in Article 29. Now let's come to Article 30. It is only for the minorities. Okay, it is only for the minorities and it is giving the right, as we studied in the article, in the question itself, right to establish and administer their institutions, right? Educational institutions. Which institutions? Educational institutions. Okay. So please remember to see these words. Please remember to see these details when you are actually answering the question, that is establish and administer educational institutions. The second thing is that if there is any piece of land or property that the state is taking away from them. So if property is being confiscated or property is being taken away by the state, because right to property is not a fundamental right anymore, so that shall not restrict them. That shall not restrict the religious or linguistic minorities from establishing their own institutions. Fine. So state has to make sure that they compensate the people for taking away their property. And this provision was enacted by 44th Constitutional Amendment Act. Right? This provision was enacted by the 44th Constitutional Amendment Act. Otherwise, if there are religiously dogmatic characters in the government, then they can take away the land of religious and linguistic minorities and stop them from creating their own educational institutions. Okay, then that is there. So cultural and educational rights. Article 29 for all sections of the society, Article 30 only for religious linguistic minorities. Moving on to the next question. Consider the following statements regarding right to equality in India. Again, we are coming back to right to equality. So, statement 1 says that reservations in educational institutions are based on caste. And statement 2 says that reservations can also be provided for socially and educationally backward classes. So, what do you think is the answer to this? See, arriving at this answer is very easy, because under right to equality, under Article 15, the word that is mentioned, the term that is mentioned is socially and educationally backward classes. The word caste is not mentioned. Where is the word caste mentioned? That there will be no discrimination on the basis of religion, race, caste, sex, or place of birth. But when you want to give reservation, when you want to give affirmative action, then can you use caste? Of course, we are using caste, but in constitution, the word that is mentioned is socially and educationally backward classes. And as we all know, caste is the backward castes are socially and educationally backward classes also. Right? So that is why the first statement is incorrect over here, because right to equality in India पूछा गया है. It is not asking you for right to equality in general. Okay? So if you want to know about right to equality in detail, we have covered it in the last class. You can go to the lecture of last class. Okay? Let's go on to so here, the first statement becomes incorrect. So you are left with only one option, that is option number D. I hope that is clear. Moving on. Okay. Consider the following statements regarding right against exploitation under fundamental rights in the Indian Constitution. Immediately go to Article 23 and 24. Right against exploitation includes the prohibition of forced labor. Child labor is allowed under certain sections, certain circumstances, as per Indian Constitution. Slavery is not covered under the right against exploitation, and the Constitution does not explicitly define what constitutes forced labor. Okay, so what do you think is the answer? Now, in these kind of questions, you have to go statement by statement. This is the key. When there are too many statements and each statement is asking something, some new information from you, you have to go statement by statement very carefully. So right against exploitation includes prohibition of forced labor. Yes, definitely it does. Begar is mentioned in the article itself. So it does include forced labor. Then child labor is allowed under certain circumstances as per the Indian Constitution. Now, child labor word is not allowed, but people, the children, can work under non-hazardous industries. That is allowed, right? The children can work under non-hazardous industries. So that is actually allowed. Under Article 24, which is talking about the freedom from exploitation for the children. Okay. So this statement is actually correct. Then slavery is not covered under right to exploitation. This is wrong. Slavery is covered under right to exploitation. If the word would have been explicitly, then the answer would have been different, because slavery as an explicit term might not have been used, but slavery has been covered under right against exploitation. So this statement becomes incorrect. Fourth statement, the Constitution does not explicitly define what constitutes forced labor. This is absolutely correct. There is no clear understanding of what forced labor entails, and that also creates a problem. So here we have three correct statements. So answer becomes C. Okay, I hope this is very clear and very easy for you to understand. Now, let's just quickly revise our articles 23 and 24, which give us the right to freedom from exploitation. Okay, right against exploitation. So, right against exploitation comes after our right to freedom, and it comes before our religious rights. So, Article 23 is a wider article. Article 24 is focused on the children. Article 23 is talking about prohibition of traffic and forced labor. So this is for the entire population of our country, and this is applicable to citizens as well as non-citizens. And I don't want you to remember this like a fact. I want you to remember this through logic, that you cannot actually exploit anyone who is not, you cannot exploit your citizens, and you can of course not exploit someone who is not a citizen as well. Fine. So, prohibition of traffic and of forced labor, and this particular right is also applicable against private individuals. Okay. So, even private individuals, private companies, it is applicable against them, because these small shops, these small dhabas, or maybe bangle making factories, any kind of factories, they have very torturous conditions, right? Torturous conditions of work. So this has to be applicable against private individuals, and this is indeed applicable against private individuals. Now, what is included in traffic in human beings? Traffic means taskhari. Traffic means selling and buying like objects. So it includes one is selling and buying, right? Then another thing, selling and buying of human beings, their organs, everything. Another thing that is covered is the Devdasi system. The Devdasi system is also supposed to be illegal under Article 23. So you can get a question in your prelims that Devdasi system is unconstitutional under which article? Article 23. Then another thing is slavery. Slavery. And then there is forced prostitution. So please understand prostitution, and this the judiciary has made amply clear that if someone is doing prostitution by their own will, they will not be considered prostitutes or criminals. But if they are being forced into it by someone, or if someone is running a prostitution racket, then that person will obviously be implicated as a criminal. Here, Article 23 also talks about imposing compulsory service. Article 23 also talks about imposing compulsory service by the state. That means that at any point of time when there is war and the state wants us to fight the war because there is lack of fighters with the state, then the state can impose compulsory service on all of us, and religion, race, or caste will not be a bar for it. However, religion, race, caste, or this class cannot be a bar for it, but sex can be a bar for it. That means it might become a rule that only the men of the country will be called for compulsory military service and women will not be called. Right? Right now in Russia-Ukraine war, you must be seeing that men are being drafted. Right? Men are being drafted means that whether the person wants to serve in the army or doesn't want to serve in the army, the person has to go to extend his services to the army. That is called being drafted. So if tomorrow, God forbid, that happens in India as well, Article 23 gives the state this right to give us a compulsory military to extract from us compulsory military service. Okay. I hope that is clear. You can get a question wherein you will be asked under which article is compulsory military service constitutionally allowed. So that is Article 23. Now, let's come to Article 24. Article 24 is about prohibition of employment of children in factories, etc. So, Article 24 is focused on children in factories. Okay. Factories, etc. That means any kind of hazardous occupation. So, just remember the age group of children which are being talked about in Article 21A, that is 6 to 14 years, correct? Here, the age group that is being talked about is 0 to 14 years. The age of 0 to 14 years, children cannot be employed in hazardous industries. However, as we just saw in the question, they can be employed in non-hazardous industries. So, for example, you have seen that children are there in small movies. They're there as small characters in TV serials and these kind of entertainment industries. So these are non-hazardous. And if you know, any kind of movie which has child actors in it will always have a disclaimer. Whether it has animals in it or child actors in it, it will always have a disclaimer that no children were harmed during the filming, no animals were harmed during the filming. Why is it necessary? Because these hazardous industries have given their undertakings that they are not exploiting the children, because the more time children spend in these activities, they are away from their school, right? They're away from their academics. So it has to be make sure that it is non-hazardous. So on these lines, the Child Labor Act means the Child Labor Prohibition Act has been has been passed in 1986, right? It has been amended in 2016. So that is there. This is what is there to know about Article 24. Please know that children can be employed in non-hazardous industries. However, even the non-hazardous industries which were earlier allowed, so for example, non-hazardous industries like working in a dhaba, working as domestic employees, working as domestic servants, etc. Even those employments which are not considered hazardous, even they are not allowed since the year 2006, when Supreme Court ruled that way. So that is why it is always said that, whenever you are having a servant at your home, you are not supposed to employ anyone who is younger than 14 years of age. That is not allowed under law. Okay. So I hope you understand where does all of this come from. This comes from Article 24. So right against exploitation, it should be very clear. 23 is about traffic and forced labor. 24 is about children in factories, etc. Moving on. With reference to fundamental rights in Indian Constitution, consider the following statements. The fundamental rights are enforceable against private individuals and entities. The president can suspend the enforcement of fundamental rights during a national emergency. The right to equality under Article 14 guarantees equal distribution of wealth in the country. And the Supreme Court can issue writs only against the government and not private individuals or entities. What do you think? How many statements are correct? Only one, only two, only three, or all four? See, first statement is correct actually. Fundamental rights are not just against the state. So there are some rights, for example, Article 17, right against slavery. Then Article 21, freedom, protection of life and liberty, right? Article, for instance, 25 to 28 also, they will be applicable to private individuals as well. No private individual can take away your right to freedom, right? So first statement is correct. If it would have been written that all the fundamental rights are enforceable against private individuals, that would have been incorrect. Okay, so first statement is correct. Then the president can suspend the enforcement of fundamental rights. Absolutely, we have talked about it. Under Article 359, all the fundamental rights can be suspended except two. And I have told you those two articles in the last class. Please tell me which articles cannot be suspended even during an emergency, even during a national emergency under Article 359. Please tell me this, and I have told you this in the last class. Okay. Then right to equality under Article 14 guarantees equal distribution? No. We are not a communist country. We are a welfare state. So we do allow people to earn money. We do allow people to become rich. But we will not allow a regime of inequality to prosper. So third statement is incorrect. And Supreme Court can issue writs only against the government, not private individuals. This is again incorrect. There is habeas corpus, right? Habeas corpus can be issued against the private individuals as well. Okay, so fourth statement becomes incorrect. So here only two statements are correct. I hope this is clear, and I also hope that questions are becoming easier and easier with each emerging questions as you have now revised the fundamental rights. Now, increasingly, my job would be to tell you how to handle these questions rather than tell you more and more of information. Okay, let's go to the next one. Application based question. The government decided to curtail the freedom of religion in the event of a public health emergency like COVID-19, leading to restrictions on religious gatherings. Which article empowers the government to do so? Which article empowers the government to do so? So now going forward, I want that you are able to tell exactly what each article stands for. So you see Article 15 is about the equality, the right against discrimination on the basis of religion, race, caste, sex and place of birth. Article 26 is about rights of religious denominations to actually protect and preserve and administer their religion, right? Administer their religion, manage their religion. Then Article 21 is right to life and personal liberty. And Article 25 is the individual right of freedom of religion, right? Within Article 25, it is very clearly mentioned that subject to public order, morality and health. Subject to public order, morality and health, every person will have the right to practice, profess, propagate and believe in conscience in their religion. So Article 25 itself has built-in provisions for maintaining health. Okay, so please make sure that whenever you are having such application based questions, you are able to designate You should not immediately go to Article 21 that we are talking about COVID-19. We need to protect our right to life. The point is, the gist of the matter is freedom of religion. And freedom of religion is promised under Article 25. However, within Article 25, there is a mechanism to restrict these rights on the basis of public order, health, morality. I hope you understand this. Next question. Which one of the following statements best reflects the role of fundamental rights in the Indian Constitution? This is a philosophical question. They ensure the protection of individual liberties. They grant privileges to individuals. They primarily pertain to political and social rights. And they are to protect the Constitution and its values. What do you think is the answer to this? See, the thing is, you must be confused in two options. The first is they ensure protection of individual liberties, and the D part is they are to protect the Constitution and its values. Why are B and C eliminated? Because we do not have any privileged class in our country, and that is one of the meanings. When we studied preamble, we studied republic, and one of the meanings of being a republic is that there is absence of any privileged class. So fundamental rights do not give any privileges to anyone out there. Okay. Similarly, why is C eliminated? Because they do pertain to political rights, but they do not pertain to social rights. Social rights are given by DPSPs. Also, I want you to give and pay attention to the word best reflects. That means that more than one statement can appear correct to you, but what is the primary role of fundamental rights in our country? And these kind of questions are coming up increasingly in our UPSC examination, wherein your interpretation is being asked. So, more than protecting the Constitution and its values, fundamental rights are about protecting the individual liberties. These are people-centric rights. These are liberty-centric rights. They matter to the people more than they matter to the Constitution or the state. Right? So, here the answer becomes A. Primary role is to maintain the individual liberty, not individual privilege. Please, in these kind of questions, it can be a narrow road. Some of you might have marked D as the answer, but the answer over here is A because it's fundamental right and they are concerned with the rights of the individual itself. Okay, moving on. Which statement accurately characterizes the relationship between fundamental rights and directive principles of state policy in the Indian Constitution? Fundamental rights are subordinate to DPSPs. Fundamental rights and DPSPs are mutually exclusive. Fundamental rights and DPSPs are equal in status, and fundamental rights take precedence over DPSP. Now, please understand there is a series of cases that you need to understand to be able to answer this question. So, first of all, fundamental rights and DPSPs. What is the primary differentiation? Fundamental rights are enforceable. That means you can go to the court to get them enforced. DPSPs are not enforceable. This is the primary thing. This is the thing that separates fundamental rights and DPSPs. However, historically, it has been seen that sometimes fundamental rights are given priority over DPSPs. Then maybe in some cases, the DPSPs are given priority. So there's a lot of subjectivity that has always been there in this regard. And a lot of litigation also has happened in this regard. So here what I want you to remember is a series of cases which will help you to answer any question that comes from the debate between DPSPs and fundamental rights. See, Just first see the cases which I am writing. Just see the names of the cases. And then I will tell you what each case is about. I'm just going to tell you the chronology. You don't even need to remember the year, etc. Always feed in your mind only that information that is going to help you, right? Not unnecessary information. Champak Dorai Rajan case. Then we have Golaknath case. Then 24th Constitutional Amendment Act. Then we have 25th Constitutional Amendment Act also. Then Kesav Nanda Bharti case. You all know this. And then we have the Minerva Mills case. Okay. So we have 6 things. Okay. 6 cases and your amendments which are important. I think Minerva Mills is not visible. Just this is Minerva Mills. Okay. Okay. So the first Champak Dorai Rajan case, the Supreme Court said that fundamental rights are more important than DPSPs. Okay. Fundamental rights are more important than DPSPs. Then this was added on. The Supreme Court added on and said that fundamental rights are immutable, and sacrosanct. Fundamental rights are immutable and sacrosanct. This means they cannot be amended. They cannot be taken away. So they are permanent. They can't be amended. Okay, this is what Golaknath case said. Okay, that's Golaknath case. Second case in our chronology. Now, of course, the power of amendment has been taken away from the Indian Parliament. So, Parliament is sure to respond to it. So, here we have the 24th Constitutional Amendment Act, which is, of course, enacted by the Indian Parliament, which said that Parliament can take away any fundamental right. Basically, it said that Parliament can amend any fundamental right. Okay. Then comes Article 20, then comes 25th Constitutional Amendment Act, which also seeks to add on the power of the Parliament. It adds Article 31C to the Constitution. Please understand the chronology, how judiciary and parliament are playing tug of war with each other, to understand and to make it clear which is more important, DPSP or fundamental rights. So 31C was added and it had 2 aspects to it. One aspect said that any fundamental right which is enacted to implement Article 39B and Article 39C shall not be null and void on the basis of violation of Article 14, Article 19 and Article 31. Please now listen to me very carefully. 31, right to property. It was there back there as a fundamental right back then. Okay. Listen to me very carefully. 39B and 39C are articles which are asking the state to minimize the income inequalities, to make sure that our system of governance is such that there is no unnecessary exploitation of any section of the society. So it is talking about social welfare. Article 39B and 39C. Okay. if I were to tell you specifically, 39B is talking about the ownership of goods in such a manner which is not subversive to public good, right? So the material resources like the money that we have floating around, it should not be owned entire money by, let's say, 1% of the population. That would be against the public good. Okay. Similarly, 39C said that our economic system should not be in such a manner that leads to common detriment. So my point is that 39B and 39C give the power to the parliament to enact acts like, let's say, for example, Manrega, wherein we are giving 100 hours of demand driven work to the people with taxpayers' money so that they can get income. Now, if we see, such measures can be against equality before law and equal protection of law also, right? Because some special considerations are being given to people. It can also be against our right to freedom of speech and expression. How? Because employment can be restricted by the people, right? By the state, employment can be restricted. For example, labor laws. Labor laws are there which are telling the companies that they have to give insurance to their employees. They have to give pension and whatnot. So that leads to expenditure for the company, right? But it is still there. So it might be against Article 19. Similarly, Article 31, when it was a fundamental right earlier, that was also an issue that if we want to do common justice, if let's say we want to build an orphanage on the land on which a mall was supposed to be created, we'll have to take that land. Then again, right to property will be violated. So 31C said that any act which is being enacted to fulfill these two articles shall not be null and void under Article 14, 19, 31. So it will be having more importance. So what it essentially means is that 39B and 39C become more important than fundamental rights. Clear? Another thing that it said is that any such act which is enacted to implement these shall not be subject to judicial review. Not be subject to judicial review. Fine. Now come to Kesav Nanda Bharti case 1973. Kesav Nanda Bharti case said that your first provision is fine. We don't have your problem, any problem with first provision. But the second provision is against the basic structure because judicial review is a part of your basic structure and we will not let you take away the rights of judicial review from the people itself, from the judiciary itself. So, right now, this is correct, this is not. We can always see whether a law is violating any article or any fundamental right. Fine. But still, we have not arrived at which is superior, which is not, whether fundamental right is superior or DPSP is superior. So in Minerva Mills case, the Supreme Court said that constitution lies on the bedrock of both fundamental rights and DPSPs, right? Fundamental rights and DPSPs have to be balanced with each other and constitution lies on the bedrock of this. However, the overall structure right now is that fundamental rights are supreme, more supreme than DPSPs, except for two DPSPs, that is Article 39B and Article 39C, which enjoy a more important position than your Article 19 and your Article 14, because Article 31, right to property, is not a fundamental right anymore. I know it can be a little difficult to grasp all of this. Okay, but just remember, just see this part again. First of all, you'll be able to remember. And second is, just remember that you have to do this to solve these questions. You do not have to do this to write a thesis. Okay, so just remember the chronology of these cases. Just remember the reason why this happened and remember the current position. Okay, just remember the current position. You will be good to go. Fine. Don't go into a lot of details. I have made everything here for you. You can take a screenshot, you can write it in your notes, anything that you want to do. Let's move on to the next question. Regarding the imposition of reasonable restrictions on fundamental rights, which statement is accurate? Restrictions on fundamental rights must be reasonable and can be imposed only by Parliament. The judiciary alone has the authority to impose restrictions on fundamental rights. Restrictions on fundamental rights must be prescribed by law and must be reasonable. And fundamental rights can never be restricted under any circumstances. Now, again, here you must have been confused among two statements. One is restriction on fundamental rights must be reasonable, can be imposed only by Parliament. Restriction on fundamental rights must be prescribed by law, must be reasonable, right? Both the statements in this way are correct. However, the statement which is broader over here must be taken into consideration, right? So, broader statement is statement number C, that is restriction on fundamental rights must be prescribed by law and must be reasonable. Now, please understand that after Article 32, there are some more articles which you need to remember and which are giving sort of the exceptions to fundamental rights, and it's very important that you remember them. So let's just study the exceptions to fundamental rights. See, when you're talking about exceptions to fundamental rights, just see here. There are some constitutional exceptions which are given to fundamental rights. One I have already told you right now. That is Article 31C that was added by your 25th Constitutional Amendment Act. Right? So one is 31C. Okay? That is DPSP related. Another one is 31B. You know that Article 31 right to property is not there anymore. It has been repealed. Okay. And another one is 31A. Okay. These are the 31 series. Then you come to Article 32. Okay. Article 32 is for the armed forces. We'll talk about all these 31A, 31B, 31C because it's very important that you know what is the distinction over here. Okay. So, armed forces and how fundamental rights are not applicable to them. Then comes Article 34 that is talking about the martial law. Okay. That is talking about the martial law and how fundamental rights are not applicable or will not be applicable when martial law is in application. Fine. So 33, not 32. 33 is there, 34 is there, and finally 35 is there. Okay, finally 35 is there, which is talking about that how these fundamental rights will be implemented and who has the power to actually implement these particular fundamental rights. Okay, now let's talk about the exceptions to the fundamental rights one by one. See, 31A is talking about how fundamental rights would not be applicable in certain cases. So what are your fundamental rights? Right to freedom of speech and expression and things like that, right? So 31A is talking about the fact that there will be some basis on which Article 14 and Article 19 shall stand relaxed. And those bases are mentioned in the Constitution. So for example, one of the bases is acquisition of estate. Acquisition of estate by the state. That means if the state needs your property for public welfare, then your freedom of utilizing your own property, your freedom of running your own employment or your own office can be actually compromised if the state requires. So that is exception to fundamental rights. Then come to Article 31B. So in this way, there are 5 ways which are mentioned in the Indian Constitution. Then come to Article 31B, and Article 31B is related to the first Constitutional Amendment Act, by which the 9th schedule has been added under the Prime Ministerialship of Jawaharlal Nehru. Why am I adding all these facts? Is because they have been asked in UPSC Prelims again and again about the 9th schedule. So 9th schedule is like a well. Okay. You can put any law inside this well, inside this kuwa, and say that this law is related to land reforms. And that is why it should not be checked under the judicial review, because we are trying to implement land reforms. That is what the 9th schedule is all about. There was a time when 9th schedule and the laws inside 9th schedule could not be under judicial review. But then there was this case called I.R. Coelho case, which said that no, you cannot have a blanket immunity like this for any law, for any act, any schedule that you have added. So judicial review will be a part of your constitution and basic structure. So this as such is not an exception anymore, but 31B is about the 9th schedule. So please remember that. 31C you all already know that it is about the DPSPs. So any law which is seeking to implement DPSPs, which DPSPs? Article 39 clause B, Article 39 clause C, right? Not any DPSP, only these two. They shall be having primacy over Article 14 and 19. Watch all over this explanation again, and if you are having problem, you will be understanding it then. Acha, what are the other exceptions? The other exceptions are that the members of armed forces, their fundamental rights can be taken away. So what are the fundamental rights? Right to freedom of speech and expression. But armed forces, paramilitary forces, they cannot be exercising their right to freedom of speech and expression in a way that a normal citizen does, because that will hamper the security of India, right? So the parliament can put restrictions, and that is why various acts like the Army Act and the Navy Act and whatnot, they have been enacted so that it can be made statutorily clear that what are the rights that people enjoy in the armed forces and what they don't. Are you understanding? Here it is very important to know that even the non-combatants, that means even the people who do not go to the war field, even they are covered if they are a part of the overall armed forces. So the nurses, the doctors, the local carpenters that serve them, the plumbers, the gardeners, even they can have some crucial information which we cannot afford to lose. Hence, even non-combatants and their freedom of speech and expression and their fundamental rights are restricted. Right? Then come to Article 34, that is martial law. Now, what is martial law? First of all, martial law has not been defined anywhere. Martial law has not been defined anywhere, but the word martial law has been written in Article 34, and that is why we know that martial law can be imposed in our country. That is one thing. Martial law means rule of the army. Rule of the army or the armed forces. So right now we have the rule of people, the sovereignty, we the people of India, right? If for any reason, because of any reason, just like happened in Myanmar, the military takes up the control, or just like it has happened multiple times in Pakistan, the military takes up the control of the governance of the country, that is the time when martial law is said to be implemented. This is different from emergency. Okay, this is different from emergency. Emergency के लिए अलग से provisions हैं in part 18. So if martial law is there, then no matter what happens, you cannot take the leverage of fundamental rights. Anything that happens under martial law, that is the rule of the army, cannot be challenged. Please understand, this is different from Article 358 and 359. 358 and 359 are about the emergency provisions. They are not about martial law. Fine. Martial law and emergency provisions are different. Here is a place where the UPSC examination setter can actually ghumawfy you. They can actually get you in trouble. Have it very clear what is the difference between martial law and emergency. And then finally, the last article over here is that any law which is enacted to implement the fundamental rights, that law is going to be enacted by the Parliament of India and not by the state legislatures. So what does this act say? That the Parliament shall have and the states shall not have the power to implement the fundamental rights. And that is why it is very clearly mentioned, even in your M. Laxmikant, that what kind of rights can be implemented only by the parliament. So, for example, if you remember, we talked about Article 16 and how if residence is to be given as a basis of discrimination in public employment, that can be done only by the parliament, right? Then under Article 32, please write this down. Under Article 32, the Parliament can empower any other court to issue writs. This is very important. Only the Parliament can do this. But this any other court does not mean High Court, because High Court has a separate article, that is Article 226. Okay. Then when it comes to Article 33, that is the armed forces, if acts have to be passed, they have to be passed only by the parliament and related to martial law that we have just talked about. Similarly, the laws to ban untouchability under Article 17 shall be implemented only by the center. Similarly, the laws to prevent traffic in people, that is under Article 23, shall only be implemented by the parliament. So here, word only does not make the statement incorrect. Please understand this. Okay, I know there has been a lot of information in the past 15-20 minutes for you. Please try to wrap your head around it. It is always good to have some pen and paper with you so that you can grasp all this information and note this down. Okay, moving on to the next question. So the next question asks you about the fundamental rights. So let's just read the question and see what we can get from it. I know the last few minutes have been very heavy for you. So just relax your mind and let's move on to the next question. In the context of fundamental rights, which statement accurately defines the principle of equal protection of the laws? It implies that all citizens must be provided the same legal remedies. It mandates that laws cannot discriminate against citizens based on their religion or caste. Equal protection of laws means that all laws must treat every citizen equally. And equal protection of laws ensures that individuals are exempt from legal obligations. What do you think is the answer? See, the thing is that these options are very close, right? They can confuse you. So you need to eliminate the options. Okay. So let's just start eliminating with the obviously wrong options. Like option C, for example, equal protection of laws means that all laws must treat every citizen equally. No, this is blatantly wrong because some laws in themselves have some extra and special provisions for treating some sections of the society differently. So, for example, the Juvenile Justice Act, right? It treats the juveniles in a different way than you would treat a criminal, proper criminal, right? It gives some leeway to the juvenile to actually reform themselves. So equal protection of laws does not mean option C. Then see option D. Equal protection of laws ensures that individuals are exempt from legal obligations. No, this is absolutely nonsense, because law, if your laws are being equally protected and legal system is protecting you, it does not exempt you from legal obligations. You need to be performing your legal duties so that everyone can enjoy their legal rights. Okay, so this becomes incorrect. Then see option A and option B. I have always told you, whenever you are confused between two, choose the option which is wider, choose the option which has less probability of being incorrect. Okay, so here if you see option B, it mandates that laws cannot discriminate against citizens based on their religion or caste. This has narrowed down the scope. Okay, religion or caste is not the only basis on which you can discriminate. You can discriminate on the basis of class also. So, because statement B has narrowed it down, and we already know that Article 15 talks about no discrimination, you reject this statement and you actually come at the correct answer. Even in these kind of questions, you can come at the correct answer through elimination. I hope you understand that. Okay. So, moving on to the next one. With reference to fundamental right of education in the Indian Constitution, consider the following statements. The right to education is a fundamental right for children in the age group of 3 to 18 years. Private schools are mandated to provide free and compulsory education under this right. The state has the authority to regulate the fees charged by private unaided schools. Only one, only two, only three, or none. So what do you think? See, always be very, very careful in reading the statements in these kind of obvious looking questions. So you know that first statement is definitely incorrect because it is 6 to 14 years of age, right? The right to education is for 6 to 14 years of age. So you make first statement incorrect. But as soon as you make first statement incorrect and you see free and compulsory education over here, you tend to miss out on the fact that it is asking about private schools. Private schools are not mandated to provide free and compulsory education. Private schools definitely have to reserve 25% of their seats for the EWS. Yes, they have to do that. But they are not compelled to give free and compulsory education. So here it becomes wrong. The third statement, state has authority to regulate the fees charged by private unaided schools. Yes, it has the authority because state, and if you understand the this particular right will be under Article 39 clause B and Article 39 clause C, right? That overall there should not be concentration of wealth. The economic system should not be to the detriment of the common masses. है ना? So only one statement is correct. I'm very sure that some of you who have attempted this question, because this is towards the later end of the spectrum also this question, so your mind is a little boggled with all the answering. So some of you might have gone through this question wrongly, which is okay, which happens. But the purpose of the mock test is to make sure that you don't do these questions wrong in the examination, which are very, very clear. Okay. All right, so we are done with the chapter of fundamental rights. I am really happy that you stuck till the end. We covered it in 2 lectures because this is one of the longest chapters. Another long chapter that we have is Parliament. So, this is one of the longest yet most important chapters of our UPSC journey overall. This is a chapter that will help you to answer questions for other chapters as well. So, please make sure that you revise your M. Laxmikant Indian Polity book and the chapter Fundamental Rights, because of the limitation of time, I am not able to make you revise every and any fact that is there. I have tried my best to inculcate as many facts as possible. But trust me on this, there is no replacement for self-study. There is no replacement for using your own eyes and hands to actually go through the book. There is no replacement for that. So you can watch these lectures, you can take away whatever you want from these lectures, but the reality shall remain that you need to give in your own labor for this. Okay, so knowing that, just make sure that you are true to yourself. And if you want to know about this entire course, that is Revise Entire Prelim Syllabus through 3000 MCQs, you can contact us on this number. And about this, go to this website. Our agenda, our goal is very simple, that because students today have very less concentration span, so it's difficult for them to stick to books and just be stuck to books. So although being in the vicinity of books is important, but exercising your knowledge is as important, if not more. Okay, so our entire model is structured in such a way that you would be developing the art of answering the MCQs in the new form, right? Answering the MCQs in the new format of the UPSC examination. And as you can see, we have all the subjects that needed to be there: modern history, Indian polity, geography, Indian economy, art and culture, current affairs, very important. Then ancient and medieval history, environment, ecology, and science and technology. So these are all the subjects which are required to clear your prelims examination. We will be covering all of these subjects through 3000 plus MCQs. So make sure that if you are one of those who likes to solve MCQs in a very structured and dedicated manner, then you can check out this course on the website, and again, the number that is given as well. So I'll see you all in the next lecture. Keep working hard and be true to yourself. I always say that. That is my suggestion to you, and keep yourself healthy. I thank you for watching. Bye-bye.